Good afternoon, everyone. Please remain seated.
Thank you.
A very warm welcome to all present here. May I kindly request you all to rise for the invocation song. Kindly take your seats. I am Tejaswini, a final year law student at Shastra Deemed University. Today, as part of a Knowledge Leadership Lecture Forum, we are truly privileged to host an individual who personifies excellence in the legal profession, a titan of the Indian legal fraternity whose journey has not merely witnessed history, but has in many ways shaped it. It's my profound honor to welcome Padma Shri C.S. VAIDYANATHAN, Senior Advocate, Supreme Court of India, and former Additional Solicitor General of India for this special interactive session, Chat with CSV. Welcome, sir. Shastra is privileged to share a long-standing association with Shri C.S. VAIDYANATHAN. He has been instrumental in establishing the Law and Development Chair, under which the Shastra Legal Aid Clinic has been carrying forward impactful initiatives that reflect our university's commitment to justice and social responsibility. We have organized 96 camps thus far, the highest by any institution in India. Sir, your career trajectory is truly remarkable and inspires all of us here. Born and raised in Coimbatore, Tamil Nadu, he pursued his early education in Darapuram and Pollachi, followed by studies at Sarada Vilas College, Mysore, and St. Joseph's College, Bangalore. He earned his law degree from Madras Law College in 1969 and began practicing in 1974. In 1979, he moved to Delhi, working alongside some of India's most eminent jurists, including Shri K.K. Venugopal. His clarity of thought and deep sense of integrity quickly earned him wide respect in the legal community. In 1992, he was designated as the senior advocate by the Supreme Court of India, and during 1998 to 99, he served the nation as the Additional Solicitor General of India, representing the government in numerous sensitive and high-value cases across taxation, regulatory, and constitutional domains. Over the decades, Shri Vaidyanathan has appeared in landmark cases that have profoundly influenced India's constitutional landscape. Most notably, he represented Ram Lalla in the historic Ram Janmabhoomi case, a momentous chapter in Indian legal history. His expertise has also shaped critical areas of interstate river water disputes and infrastructure policy, and his contributions to election law continues to guide jurisprudence today. Sir, your work spans the entire breadth of legal world, from constitutional and administrative law to competition, patents, and arbitration. Your commitment to justice, your intellectual depth, and your service to the nation inspires every aspiring lawyer seated here. On behalf of the entire Shastra family, I extend to you a warmest welcome.
Thank you. Thank you.
Every once in a while, we get the opportunity to pause and reflect, to think deeply about the ideas that shape our legal world. Today's talk with CSV Sir gives us that opportunity. Let us begin by briefly setting the stage, and we let the audience take over.
Good afternoon, sir. Sir, may I take the privilege of asking the first question today? Thank you, sir. Sir, you began your legal journey in Tamil Nadu and later moved to Delhi with Shri K.K. Venugopal. Could you please tell us about your early years at the bar, sir? Thank you.
74 when I joined Mr. Venugopal, I had given up a comfortable job, a coveted job, because I had joined DCM as a senior management trainee, and those days, three principal organizations had these management trainee schemes: Hindustan Lever, Tata Administrative Service, and DCM. So there was a pretty pay packet which I gave up and came to Chennai, because I had thought over it and then came here. When I met Mr. Venugopal first time, he said, you start coming to the chamber, to the High Court chamber, then let me see, and then wherever you should start coming to my office, we'll decide. So the first 3 months, I was not getting any sort of payment, but he asked me to come to his office within 15 days or so. My good fortune was that Mrs. Gandhi decided to make stringent laws and enforce them. And so that meant a lot of litigation for the lawyers who were in constitutional and administrative law areas. And my second good fortune was that Mr. Chidambaram was then the star junior in Mr. Venugopal's office. He could not appear in most of these cases because he was very active in Congress party. Therefore, then Mr. Venugopal chose me to be the person who will appear along with him in the habeas corpus matters challenging detention and also censorship matters. But, there's an important difference. In Madras those days, the lawyers, the senior advocates, used to have an office where the clients could meet them directly, and then the senior will entrust the cases to the lawyers. That continues even now in some of the jurisdictions, including Madras. That's not so in Delhi. So he will assess the capability of the junior and his expertise, and based on that allocate work. But my good fortune was that I had joined a senior was very, very encouraging and supportive. I joined him on 13 June 1974, and by the end of July, before the month turned, I think somewhere around the 28th or 29th July, I had moved my first admission matter, writ admission, before a single judge, and he sat next to me. That kind of practice I don't find today amongst lawyers. It's a very generous lawyer who will be able to sit next to his junior and let him move the admission. That's a kind of practice which I entered, when I entered. So I don't know whether you will be able to get that kind of encouragement today. I wish it happens, but that's not the kind of opportunity that you get today. So from then, there was no looking back. Unfortunately, there were a number of cases, very challenging cases, but very interesting cases. And where I was able to assist him. And I was happy to be associated with some cases with Mr. Nambia. He was still alive at that time, 74. In fact, when some of the detention matters of some alleged smugglers was taken up by Mr. Nambia, so I could associate with him. And that's a practice when I started.
Thank you, sir. Your legal career has grown alongside the development of Constitution. In your opinion, what are the most pivotal stages in evolution of our constitutional jurisprudence?
What is it?
Most pivotal stages in evolution of our constitutional jurisprudence.
See, today, I think if I look at the exercise of jurisdiction by the Supreme Court, I feel quite disappointed because the Supreme Court should be focusing on human rights, personal liberties, then resolving interstate disputes, federal relations. These are the aspects that should be the focus of the Supreme Court, because these are matters where the Constitution has entrusted special responsibility with the Supreme Court, whether it is Article 32 in regard to enforcement of fundamental rights, or whether it is in regard to Article 131, resolution of disputes between the union and states or in between states, etc. These are the matters that should be the special focus. But today, unfortunately, it is 136 which is dominating the Supreme Court's exercise of jurisdiction. That's a sad part. But if you look at the root cause of this, I think it is in regard to the failure, perhaps, of either the district judiciary or the High Court judiciary, because the confidence of the public in the justice administered by the district judiciary and the High Court is not there to the fullest extent. If it were there, then so many matters will not be coming to Supreme Court. And it is because of that today, I think what the Constitution envisaged in terms of reaching justice to the people, unfortunately, is not achieved fully. And we see huge arrears everywhere. That's unfortunate thing.
Thank you, sir. I think we'll let the audience ask a few questions.
Good afternoon, sir. And my question to you is that, being a diverse country, how can we balance between religious rights and constitutional morality, specifically when they are in conflict?
Sorry, repeat that.
Yes, sir. Being a diverse country like India, how can we actually balance between religious rights and constitutional morality, specifically when they are in conflict?
I'm not able to appreciate the question. Can you elaborate on what exactly you have in mind?
Yes, sir. There is actually a conflict between the religious rights which has been enshrined in the Constitution and also the constitutional morality which has been followed by the Supreme Court of India.
Okay.
Yeah.
See, we all follow as members of humanity, as citizens, we all have a sense of morality. But that's different from the constitutional morality that we are talking about. You're asking about constitutional morality, really. Yeah. There has been a theory of constitutional silences. Now, when, Constitution is written not for today or tomorrow, but it's written for a long time. It has to evolve. It evolves with time. It also has to gel with the social norms. So when we talk of constitutional morality, it is in that sense an attempt by the court to blend the kind of written law with the social mores and customs, and in a manner in which it is acceptable to people. Why do we have laws at all? What is law's purpose? To have an orderly society. To have a society where things are put in a shape where you will be able to progress, you will be able to advance the interests of the general lot of people for achieving happiness, for achieving a level of economic comfort, solace, their basic needs being met. All these are things. Now, the Constitution provides for some of these things, doesn't exactly say that, okay, you have a right to your home, you have a right to peace, you have a right to happiness, you have a right to privacy. These are not something which are articulated in so many words. So you read them into the Constitution, and in a similar fashion, you have certain things which are unsaid, but like for example, the legislators go on, the persons who are campaigning for getting elected as legislators go and seek vote for themselves, get elected on a particular party ticket. After getting elected, they go and exchange in horse trading, and they want to shift sides wherever they get some office, some economic benefit, etc. Now, is it constitutional moral? Is it? Therefore, these questions arise, and then the courts have to interpret the Constitution in a manner that, okay, this doesn't accord with our general accepted norms of morality, constitutional morality. Therefore, something needs to be done. So either the court tries to evolve something, or there's sometimes, like in the 10th schedule of the Constitution, which has been introduced, the Parliament tried to do it. Of course, that has practically of no use, because the Speaker today, in most of the cases, is completely ineffective. So I'm just giving you one example of how constitutional morality is an essential requisite for an orderly functioning of the democracy. So,
What's your view on judges giving press conferences? Recently, Justice D.Y. Chandrachud said he has prayed before the deity to arrive at a conclusion in Ram Janmabhoomi case. And he also said it is a fundamental act of desecration, whereas the judgment says otherwise. So it has sparked a national debate saying how can a judge of a secular country can mix his personal faith in judicial duty. So what's your opinion on this?
See, I have grown up as a lawyer at a time when I have seen some judges who, used to freely mix with lawyers, go to public places, places of worship, etc. There was no, and we could discuss other subjects, but perhaps not subjects which they deal with in courts. Today, we have conflicting expectations in regard to judges. One, we want them to be completely cut off from either the lawyer community or the public and keep away from them and, keep some distance. At the same time, we want to be accessible for the purpose of disposal of cases or etc. These are very serious conflict in the two. And today, the media, particularly the social media, is so active. Anything that is said gets projected in a big way. So one thing that a judge who is functioning in today's world has to realize is that whatever he says tends to get publicized immediately, and if he says something which is very sensitive, it gets immediately magnified, and it becomes viral. The communication it's spread. So one has to be extremely careful even while speaking in court. I belong to the old school of thought where I believe that the judges should speak only through judgments and not outside I'm particularly about judgments which they have given, of which they have been a part. But not everybody is like that. And, it's very interesting that in US Supreme Court, when there are conflicting judgments, sometimes the dissenting judges are so strong in their views, in criticizing the majority judgments. You don't have that kind of practice in India so far. Maybe it will come sometime in future. See, this is, I think each one has to have some kind of a rule in regard to this. But as a rule, no judge should speak about cases which he has dealt with in court or which are pending before him. That, I think, is completely inappropriate. Post-retirement, whether one should speak about some of these, there could be there may be need for some flexibility at times. But in this matter, in a highly sensitive matter, whether Chief Justice Chandrachud should have spoken in this manner, I have serious doubts. I personally would have preferred if he had not spoken about it.
Thank you, sir.
Good evening, sir. I'm Muthu from final year law student. So, my question is that, considering how the media often shapes public understanding of law and justice, is there any case from your career that you feel didn't quite receive the attention it is supposed to? And building on that, how do you view an advocate's role when it comes to engaging with or choosing to distance themselves from the media in such situations?
Sorry, can you
Yes,
tell
sir. So basically, I want to ask this question in a twofold manner. So one is that regarding the a case where you felt media did not cover quite enough, and the other being what should an advocate's role be in such cases?
I think media covers cases where, it draws attention and where it can, become viral, where it can have so many people reading it or watching it. There are so many cases where media should pay attention. No, I will give an instance. Indian Express, during the time of Arun Shourie, highlighted the case of one Kamala. I don't know how many of you are aware of that. This is about girls being bought and sold and things of that sort, and how they were being taken away from the parents or from the villages and then taken. And it caught the attention of the court, and then some attempt was done. This is the kind of cases that should receive more attention. Chief Justice Anand, in regard to treatment of women in places of work, and when there was no law, he sought to bring about some kind of discipline, and then said that in regard to their treatment, harassment, all that kind of thing, some action should be taken. I think these are the cases which should receive greater attention. But it is, let me say, I have stopped watching television completely. Because today television picks up 3 stories which, according to them, will attract listeners and hold their attention, and focus on that for 24 hours. It's a sorry and sad state of affairs. There are so many stories of interest, of development, of, where, for example, persons from a difficult background, persons with physical challenges, who have been able to come up the hard way and succeeded. That's not being highlighted. I have appeared in several cases of even students seeking admission who have, for example, a person who had passed medicine, but then developed problem in regard to his vision. Therefore, he became visually challenged, and he couldn't get admission in postgraduate in medicine. But Chief Justice Chandrachud said, why should he not be admitted to a postgraduate course in psychiatry? He doesn't need, even if he is visually challenged, he can certainly be considered for that. I think that was a case which needed to be prominently highlighted. Unfortunately, it was not done. This is the kind of cases which should draw media attention. But that's not what is getting the media attention, because that doesn't interest them. That doesn't buy them media time. That's the attention. Sorry, what is the second half? Advocate's role. See, I have, my view may be somewhat biased and prejudiced, because I stay away from all the evening debates that you see in the television channels. I don't give bites to the media in regard to cases in which I appeared, even in cases where I'm likely to appear or have appeared. As a matter of policy, I have kept away from that. But that is not necessarily everybody's way of thinking. You find lawyers who have argued a matter in the morning, appearing later in the evening in the television and espousing the cause virtually, the case in the media, whether they have won or lost in the court. But that's something which I personally do not approve of, but they have their own point of view. Therefore, this is part of the ethics of the profession where each one has his own view. My view is I should not take part in that, but somebody else has a different view.
Thank you, sir.
Good evening, sir. I'm Lalit. I'm a fourth year student, sir. The question that I have is that, in the context of criminal matters, are there any differences as to the exercise of power by the Honorable High Court under Article 226 of the Constitution and Section 482 of CRPC, sir?
Oh, see, there is judicial discretion is something where judges will differ, and 226 and 482. But the problem today is, I have, as a lawyer, watched grant of bail, for example, by Justice Krishnasamy Reddy, I'm talking about 1977-78. He used to have about 200, 300 cases. And he would clear off most of the cases by the end of the day. And 3-line, 4-line order, not very lengthy orders. And those days, bail applications, if they are filed, the public prosecutor will have to get the case papers and the officer concerned. So if it is taken up in the morning and if it is not ready, it will be taken up in the afternoon, it will be disposed of. But that kind of disposal by the High Court, whether it was in 226 or in grant of interim orders in High Court, normally if they are prima facie satisfied, they will immediately grant. That may not be elaborate reasons. But today what has happened is, unfortunately, the Supreme Court has started commenting adversely on this kind of orders. They want reasons in regard to grant of interim orders, grant of bail, which may even ultimately affect the trial of the case. I don't know. I mean, this is rather unfortunate. Now, what has happened is, therefore, today the judges are very, very, they are hard pressed for time. They have to still dispose of and then give very reasoned order. And reasons means it can't be, when you talk of reasons, it has to be at least 4 or 5 pages. It will be. So, time. Second, they'll say, why should I take the responsibility and then grant a relief? Let them go and get it in Supreme Court. That's a kind of approach that has come about, which is not a good thing. Therefore, Supreme Court's comments on this kind of exercise of discretion while granting discretionary relief, whether like 226 or 482 or in grant of bail, etc., is adding to the burden of the Supreme Court by their adverse comments that are being passed against the High Court. It also making the High Court very reluctant to grant relief, which is not a good thing. And High Court in turn is adversing commentary on the district courts. With the result, district courts are also reluctant to give interim orders or grant bail. And that comes to High Court, from there they go to Supreme Court. I think we need to have a relook at the whole thing and should be able to trust our judges, district judiciary and high courts, They are exercising their discretion and it should be left to that, and Supreme Court should not be interfering in every matter. Yes, not all orders will be right, but if there are matters which need to be corrected, which cause irreparable prejudice, then you interfere. Otherwise, it should be left at that.
Thank you, sir. When you mentioned about the discretion of the court, I can't help but think about the basic structure doctrine. Do you think we've gone far away from what the framers initially envisaged?
No, I would say that the court had to read basic structure into the silences of the Constitution and impose a kind of restriction. You can't today, in the garb of amending the Constitution, do away with the democratic form of government or take away the right to freedom of speech, right to liberty, etc. That is something which is a complete no-no. Basic structure theory is an important safeguard which needs to be continued, which needs to be, I think, as times go by, we perhaps may have to expand the restrictions in regard to the constitutional amending power.
Good evening, sir. In a recent interview, you had mentioned that while preparing for the Ram Janmabhoomi case, we went through almost 80,000 pages of material and had to prioritize and compartmentalize the arguments for effective presentation in the court. Could you share how you approached that process without being overwhelmed by such vast records and how you managed your time properly?
No, number one, when I say 80,000, you have to keep in mind that some of these are a duplication because some will be in original, some will be translated. So in actual number of pages, it may be less. But that's not the question. See, first, we have to keep in mind, fortunately, in that case, there were certain admissions which had been made at the first hearing in regard to belief and faith that Ayodhya is the place of birth of Ram was something which was accepted by the defendants, Muslims also. Then it was only a question of which was the actual place of birth. So one had to find evidence to show what could be that place. So which was the place which was considered sacred by the Hindus. So you look around in the material, in the evidence, in the travelogues, in the oral evidence, in various other material. So you look around for that kind of material. And in fact, I was not involved at the stage of trial, but the persons who did the trial had to do an extensive work going into all this. In fact, they had put in much harder work, much more work than what I did, because I built upon what they had already, the foundation had been laid by the trial lawyers. So full credit must go to the trial lawyers. And therefore, I built upon that, and we all tried to see what is the material, and then, yes, I'll give you, forget this case for a moment. Take the Kaveri water dispute. The evidence of witnesses went to some 15,000-20,000 pages. At the end of the trial, when you actually argue the matter, maybe it is just about 500 pages which are really material, because where some crucial admissions have been made, some crucial data have been furnished. So you will have to sift all the material and try to get those and then keep it ready. At the end of the day, that's it. Therefore, when you go through the material, as a lawyer, I have always believed that I must go through the entirety of the material. So that's my practice. I normally do that in any case. Then I pick out what is the issue at hand, what is it that what are the likely questions from the court which I have to be ready for. So get myself armed with those answers. Get ready with the material which will be handy to give up. I was reading 2 days ago the transcript of the arguments which have been made in the US Supreme Court in regard to the imposition of these tariffs by Trump. You know, interestingly, the opening statement by the Solicitor General on behalf of the government was 1.5 pages. Opening statement of the Katyal, who was appearing for the person who had succeeded in the court below, challenging the tariff, was again 1.5 or 2 pages. So, but they were ready with all the answers. So many questions came from the 9 judges. So many questions came, and it was more. It was a packed session. Therefore, in the 2 hours argument, there were a host of questions, and Chief Justice had a difficult time giving chance to all the judges to ask the questions from the lawyers. So, but what it showed was the kind of preparation that had gone in by the lawyer to be ready to come up with answers. So that's ultimately we are there when we fight a case. We have to satisfy the judge that yes, this is a point, and we should therefore anticipate the kind of doubts that will be raised, the questions that will be asked, and should be in a position to answer it with backup material. That's what we look for.
Good evening, sir. My question is, GST Council established under Article 279A of the Indian Constitution has the power to determine GST slab rates. But Article 246A grants power for the state government to modify the slab rates. Whether state government can modify the SGST slab rates?
Just to clarify, this is regarding the GST regime. GST.
Yes, sir.
No, what is the question? The power of the state in regard to?
Under Article 246A, state government has the power to make rules regarding GST, sir.
Yeah.
But under Article 279A, GST Council was established. Now GST Council are deciding the slab rates. So if the state government wishes to modify the slab rates, which regarding to the state GST, can they modify it or not?
No, I don't think so, because see, GST has been evolved by consensus, and all questions which could give rise to a conflict in regard to exercise of this power, either taxation power. The idea is that it should be resolved by this council, 279A. So state government's powers in this regard is very limited. If the state government is not happy about some of the things that are, like for example today, the cesses and cess charges that are being imposed, and there my view may be slightly different from the view of some of the others. My personal view is that lakhs of crores are being collected as cess and cess charge and are not being used for the purpose for which it is being collected, and are not being shared with the states. If the states are agreed by that, then it had to be by a resolution of that dispute. They have to raise a dispute under Article 131. They can't seek to exercise the legislative power to override. I don't think they will be able to succeed in passing a law repugnant to the central GST law or trying to have it, it being effective. That's my view. So, but just diverting from that subject a little bit, I have a view on what was intended when powers were to be given to the panchayats and municipalities. The state governments are not willing to part with powers in favor of panchayats and municipalities, and central government is not willing to give greater financial powers to the states, both of which, according to me, are not consistent with the federal principle. That is not what is contemplated. That is not in the larger interests of the country in the long term, my view.
Hello. Good evening, sir. I'm Arvind Vijay, a fourth-year law student. So, sir, which quality makes a legal argument persuasive to an already skeptical bench? Which quality makes a legal argument persuasive to an already skeptical bench?
I'm not able to follow. Actually, it's not clear.
Which quality makes a legal argument persuasive to a bench which is already skeptical?
Which quality? I think any argument will have to be based on good facts and law, ultimately. But I think if you are talking about skill of advocacy, I think the best when we look at various lawyers, the most skilled lawyer is one who doesn't get provoked even in a hostile court and can calmly and with equanimity marshal the facts and law and present it in a very articulate fashion. So I think the most important thing is, your effectiveness as a lawyer is seen in the hostile court. If you are able to persuade a court, and you can take it from me that in actual practice in a court of law, very often you find the judges want quick answers. You have to be, particularly in Supreme Court, you sometimes get 2 minutes to argue a case, sometimes only 1 minute. So you have to be quick on your legs and should be in a position to answer. So your ability to immediately respond to the court, that's a thing, that's important.
Okay. Thank you, sir.
My heartfelt greetings to sir and everyone gathered here. Sir, my question to you is, as young students today, we sometimes face self-doubt and are sometimes daunted by the demands of our profession. So what would be your advice to students like us?
At a time when I entered the law college, there was no competitive exam. We could walk into a college. That was the last option. Engineering was the first option, then medicine, etc. Today you have 2 million lawyers, 20 lakhs lawyers. Every year, 75 to 80,000 lawyers come out of college. It's a huge, huge number. And out of 20 lakh and in fact we don't even have an exact count of lawyers, which is unfortunate. The Bar Council of India doesn't have a live register of how many lawyers are there. It's an approximate count. Hardly 3 lakh lawyers pay income tax. Of them, maybe about 20,000-30,000 are paying income tax on an income of more than 5 lakhs. So the rest no. This is the challenge today of a lawyer. When we studied, the fee structure was not so high. Today, the colleges have to be self-sustaining. Therefore, the fee structure is high. Because those days, it was essentially law colleges funded by government. So the fees were, were nominal. Now what happens? To put a child through the legal education, the parents sometimes have to borrow, or the student herself has to borrow. So at the end of the 5th year, when you come out, you suddenly find that after 1 year's period, you have to start paying your EMI. You have to be ready with an income. So you seize at whatever is the first good opportunity to, if you are given an offer from a corporate either company or a corporate firm or a firm practicing in corporate work who are able to offer you good money, you take it up. Now, this is the biggest challenge that a lawyer faces. If he or she wants to be in either litigation or pursue further education, then today the biggest challenge is in regard to the immediate need of money. And I'm not saying that in any decrying manner, but I am saying that is a reality today. So I am not surprised that the cream of law college students go and opt for something that will give them immediate good monetary remuneration, and don't want to take the risk of litigation practice, which will mean 4 to 5 years of initial suffering with prospects of good practice later. But to undergo that first initial 4 to 5 years of suffering, they find it very difficult to sustain. This is the biggest challenge. We have to come up with some ways where the law students, meritorious law students, are supported for entering the litigation practice also, because we need good lawyers in litigation.
Thank you, sir.
Can we take two or three questions?
Yeah.
Sure, thank you.
A very good evening, sir. I am Bhanumati, 4th year law students. We are very honored to gain your intellectual wisdom of knowledge, sir. Thank you for giving these opportunities to SASTRA students. And my question to you is that what is your opinion on AI in legal profession and adjudication? And if in future we are about to enact a legislative act on framework for legal framework for AI practice and regulations, what will be the necessary implications, sir?
The first part is in regard to the legal practice.
Use of AI in legal profession and adjudication, sir.
Yeah.
And the second point is, what will be the necessary implication if you are about to enact a legal framework?
No, I don't know. I mean, will you please explain what exactly is the
What is your opinion about use of AI in legal profession?
Yeah, okay. AI is a good servant, but not a good master, number one. So you can use it, as a tool. Yes, those days when we had to do research, you went through all the cases, case laws, you look for the digest, quinquennial digest, all these, so many digests. Today, at your fingertip, you'll be able to ask a question, either ChatGPT or Perplexity. You just articulate your question and you'll be able to get the answers. Yes, you can use it, but very often I find that when you get the answers, such a case law doesn't exist. So you have to be very careful. You have to cross-check and see whether there is such a case law. In any case, what is going to happen is that routine work, which is now being done either in terms of drafting, preparing legal documentation, which needlessly cumbersome documentation, that will go. I want to take an aside at this stage. See, today legal documentation corporate contracts are drafted turning into 50, 60 pages. The longer the page, the greater the scope for litigation. At one stage, when I was interacting with Mr. Viketichari. Mr. Viketichari was the Advocate General for the State of Madras for a long time, nearly 20-25 years. He said a sale deed for a property should be maximum 2 pages, 1.5, 2 pages. Because what do you need? You need the name of the seller, you need the name of the buyer, you need the description of the property with the boundary, and you need the consideration. All the rest of the things are contained in the Transfer of Property Act. Whatever is the assurances of the vendor, whatever are the responsibilities of the buyer, they are all contained in the Transfer of Property Act. You will need to put it in your sale deed. So all these, this should not take longer than 2 pages. Now you have sale deeds running into 20 pages, 50 pages, which only create more problems. This part was completely an aside, but I am saying this kind of work, documentation work, is something which can be replaced effectively. The time that is taken, AI can take over and you will be able to get this one. Even today, most of them, you have the templates which you follow. Most of the corporate world, they have the templates, you just fill in and adapt it. So that's the kind of thing that can be done. I'm not sure whether AI today will be able to think in terms of how do you challenge a legislation. When a legislation is passed, all of you as students, if you are asked to draft a writ petition to challenge a law, you have to look at, is it constitutionally valid? In what sense? One, legislative competence you have to look at. So does it fall within any one of the lists? Does the legislature which has passed the law, does it have the competence? Does it fall in any of this? Or does it violate any of the fundamental right? Or is it subjected to any other constitutional restriction? Now you have to think in terms of, you have to have some original thinking. I'll give you one instance. When during emergency, when Mr. Karnanidhi was sought to be prosecuted for the so-called wheat scandal, some corruption allegations. So everyone thought it was an open and shut case. There was nothing that could be done to challenge it. So we were debating that Mr. Bangupal was the senior counsel, Mr. N.A. Subramaniam and I, we were the persons who were preparing the petition. So some thoughts struck me. I said, is there no law within the state in regard to prosecution of public servants? So then we searched and we found that there was a public person Criminal Misconduct Act which had been passed by the state legislature. So then we explored that possibility and then found that there is an inconsistency. Therefore, there is a state law which has been passed, which has received the assent of the President, and therefore under Article 254 can prevail over the central law in regard to prevention of corruption. Right? We argued that point. We ultimately did not succeed. But I'm saying this kind of thinking, critical thinking, exploring, and then finding out a point on which you can challenge either a law or some issue of law, I think that has to come only from your creativity, creative thinking, questioning mind. This can't, in today's artificial intelligence ability, I don't think they'll be able to come up with this kind of a ground and then raise it and argue. Therefore, there are limitations, but there are areas where we can use artificial intelligence.
Thank you, sir.
One last question.
Good evening, sir. In your recent interview, you have mentioned that you are very fond of books, Tamil literature, and you read a couple of Tirukural every day.
Sorry?
In your books about biographies, economics, and Tamil literatures, and you read a couple of Tirukural every day. As book is a good influencer of mine, can you recommend some book which will be very useful to the current law students?
I think you should read essentially some books on jurisprudence, human rights. These are the things. See, on law, procedure, you have ever so many subjects which are taught. First of all, don't focus only on law. Today, for a lawyer to succeed, you need to have awareness of public affairs, politics, public finance, and so expose yourself. First, I will recommend reading of The Economist, the magazine. It's a must for every student of law. It gives you a broad coverage of whatever is happening in the world, and in a fairly dispassionate, independent manner. I mean, you can't say there will be certain biases always. Whether you look at Washington Times or Washington Post or New York Times, they will always have some certain biases. But by and large, The Economist, I think, is a good magazine of repute, which gives not merely information, but a critical analysis of whatever is happening in the world. I think it is a must read for every student. Similarly, I think Foreign Affairs is another journal which is able to apprise you of what is happening in the world. Why is Trump seeking to impose this kind of tariff? What is happening today to the all the consensus that was achieved in the World Trade Organization why is it broken, what is it happening to all the international organizations which have evolved post Second World War, whether it was United Nations or various other organizations. Now, you must know, it is not enough as a lawyer for you to be confined only to the Constitution or to the criminal laws, Contract Act, arbitration. Those things, yes, but I think these are important. And any good book which can make you think, I think that's what you need to read. Okay.
Thank you, sir.
Thank you, sir. What's one motto that you would like to leave us with? One thing that's been guiding you for so many days.
Sorry?
What's one thing that you would like to tell us, one last message?
First, I must say that I'm so happy to meet all of you. So many young faces and bright smiles, happy faces. Second, the kind of questions that have been asked, I think it shows you're all people who have a very intelligent debate amongst yourself. And therefore, you are able to come up with questions like this and able to ask me. Therefore, that shows that you are able to, in your educational activities in this university, you have certain culture and ambience where you are able to think creatively and come up with all this. So that's a very good thing. Make use of these facilities and do some useful work. Think about what you can do to the society also. I think that's the most important thing. At all times, be in a position to contribute something to the society. Thank you. Thank you very much. Yeah.
Thank you, sir, for patiently answering all our questions. May I now invite Professor Srikanthan to present the memento.
Thank you. Thank you. Thank you. Thank you.
May I now invite Chiranjeevi Raghav Karthik to deliver the vote of thanks.
Good evening, everyone. I'm Raghav Karthik, a fourth-year law student, and it's my privilege to deliver the vote of thanks this evening. We would like to express our deepest gratitude to our distinguished speaker, Padma Shri C.S. VAIDYANATHAN sir, for gracing us with his presence today. This interaction has been both enlightening as well as elevated our thought process to reflect on the higher ideals of law and justice. Your illustrious career and pioneering work in constitutional, regulatory, and environmental law stands as a beacon for every aspiring law student here. We are deeply honored by your insights that you have shared and the time you have devoted to us today. At the outset, I would like to express my sincere gratitude to our Honorable Chancellor, Vice Chancellor, Dean Planning and Development, Registrar, and Professor Srikanthan sir for their unwavering support and encouragement in all our academic endeavors. I extend my sincere appreciation to the university management for their continued guidance and commitment to fostering meaningful academic engagement. A special word of thanks to the technical support team, electrical team, civil maintenance team for the diligence and efficiency in ensuring the seamless operation of today's event. Before we wrap up, I want to thank my fellow law students. Their engagement and enthusiasm makes events like this come alive. Once again, I thank everyone present here for contributing to the success of this event. Now, I request you all to kindly stand for the national anthem.